Welcome back. Will Worsham joins us now for this week's Speaking Legal discussion, where he answers a viewer's legal questions on the air. And let's take a look. First of all, welcome, Will.
Thank you.
We're going to take a look at this week's question. What do I do if I'm divorced, but my ex-husband has never taken my name off the utilities, title, or mortgage loan and has refinanced the house?
Okay, this is really interesting, and it's something that actually comes up from time to time because you've got this property, you got property that you owned it together.
Yeah.
There's a little bit of missing information in the question, as there normally is. So some questions I have. One is, how was her name on all these things, and then he was able to refinance the house without her?
Good question
Wondered
there.
myself.
There's a real interesting question. He shouldn't have been able to do that without either forging her signature or taking her name off the loan, but her name would have to be off the deed to the property in order to do that as well, which means she would need to sign a quitclaim deed in order to get that done. Now, normally that would be part of the divorce proceedings, is if one spouse is taking over the house, gets custody of the house.
Isn't that normally part of the agreement?
It is. Somebody, either the jointly held property is sold or it is awarded to one party or the other. And if it's real estate, so that it's got a title, then what's going to happen is the spouse that's not getting that house is going to sign a quitclaim deed, giving their interest to the spouse. Now, there's usually a balancing transaction where maybe there's some cash or other property. However the judge decides that should go, or the parties agree that it should go. But this scenario where it's kind of not taken care of, it's kind of just left and not handled, is unfortunate, but it happens. Frankly, it happens a lot of times in cases where people are unrepresented. And they do kind of we'll pay a couple $100s to get the documents prepared, but then they're not really represented by a lawyer. They just use like a document preparation service. So it leaves kind of some of these details undone. She should be able to maybe get if her name is not on the deed anymore, she might be able to go to city utilities or whoever and get her name taken off the utilities that way. The insurance, I'm not sure she would necessarily want her name off the insurance because it might protect her in case a claim comes. But once again, if she can get a copy of the current title at the recorder's office or however to show she's not an owner of the property anymore, she might be able to clear up some of those things. The more concerning issue is if her name is on a mortgage on a piece of property she no longer owns. What that would mean is that if he was to default on that mortgage,
she's responsible.
She's responsible for that.
And what liability could be attached
also? Total liability for that. I mean, if you've signed on that note that says, I'm going to pay this note, the fact that you get divorced doesn't change your obligations to the bank. The bank's not party to that divorce.
They could care less.
The only court that would really have the ability to modify that type of arrangement would be a bankruptcy court. Of course, you don't want to go all to that level, but really this is something that should have been handled at the time of the divorce. There should have been an order ordering him to take her name off of those items, particularly that mortgage loan, to get it refinanced, get her name off of that at the refinance. So I'm hopeful maybe that at least when it was refinanced, maybe her name was taken off the mortgage when it was refinanced. If her name's still on the deed, frankly, that's ultimately to her benefit because it says she still owns half that house.
But
that's not really hurting her.
Is she not liable if anything?
That's what I'm thinking.
You know, the eave falls off and hits someone in the head.
Yes,
that would be the problem. As an owner of the property, there could be some liability that would attach if she was somehow negligent. Now, if she could show, hey, I'm not in custody of the property, then she did nothing negligent. It's a slim chance that a negligence claim would actually attach to her. As owner of the property, I would be concerned about it. I would also be concerned more about if the property is allowed to fall into disrepair and so that the county comes in through some zoning ordinances and enforces cleanup and then puts a tax lien on the property, then she becomes liable for the cleanup that the county did on the property. So it kind of can just go all different ways.
And one of the first things, too, how did you do this without me signing something?
That's a big question.
Then now the banks are involved.
Yeah, if her name is really on the deed to the property, I'm not sure how that property could be refinanced without her knowledge.
Well, good answers. All right, as always.
Thanks.
Will Worsham now.
Find a lawyer.
Yeah, find one. If you have a legal question for Will, you can email him at wworsham@color10.com, and he will answer your question on the show. And again, as always, thank you so much. Good advice.